Welcome to today's program titled The Future of Arbitration Part 3, Unique Arbitration Issues in California. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. At this time, I would like to turn it over to our first speaker for today's program, Andrew Paley. Andrew, please go ahead.
Good afternoon, and thank you for joining us today for the third webinar in our series on the future of arbitration. Today, we will be covering three unique issues to arbitration in California. But first, a quick introduction of our panel. As Kate mentioned, I'm Andrew Paley. I'm the head of our California Wage and Hour Practice Group, and I'm based here in our Century City office in Los Angeles. With me today are two of my partners who have a tremendous amount of experience and knowledge with regard to petitions to compel arbitration in California. First up, Candace Bertoli, a partner in our downtown Los Angeles office. Among other things, Candace is currently handling hundreds of arbitrations with regard to a mass arbitration campaign against a client. And we also have Daniel Wong, who is a partner also in our Century City office, who's one of our leading PAGA experts and has been closely following the legislative attempts to overturn mandatory arbitration agreements in California. Today we'll be covering three important challenges to arbitration of employment law claims that are unique to the California landscape. First off, Daniel will be describing the current status of the enforceability of mandatory arbitration provisions and the ramifications of the Ninth Circuit's decision in the Bonta case. Candace will then cover the recent legislative attempts to undermine arbitration in California through SB 707, requiring the payment of arbitration fees within 30 days, and lay out some strategies to avoid a waiver of your right to arbitrate arising out of the failure to pay fees on a timely basis. And finally, I will be covering the increasing challenges brought by plaintiffs to electronic signatures on arbitration agreements and the steps that you can take to ensure that your petition to compel arbitration is granted. If time allows, at the conclusion of today's presentation, we will try to get to as many of the questions that you may have. If you do have questions, you can submit them through the chat function that's down at the lower right-hand corner of your screen. With that, I will turn it over to Daniel to kick us off.
Thanks, Andrew. Next slide, please. I'm sure an issue that most of you have heard already is the attempts by the California legislature to render mandatory arbitration agreements to be unlawful in California. The legislation at issue is referred to as Assembly Bill 51, or AB 51 for short. And what AB 51 did was added two sections, one to the Labor Code and one to the Government Code. And the import of both sections is that it made unlawful any mandatory agreement that was conditioned by an employer for either employment, continued employment, or the receipt of any employment-related benefit. And just to be clear, that this could apply to not just current employees, but let's say there's an applicant, somebody who is applying for a position, and a mandatory arbitration agreement will be a condition of employment in order to even be considered for employment. The scope of AB 51 potentially could include that as well. So in addition to making it unlawful to mandate arbitration agreements in the employment context, it also made it unlawful to threaten, retaliate, discriminate, or terminate either an applicant or an employee who refuses to sign an arbitration agreement. And so if there was any doubt that AB 51 would cover applicants during the application process, the statute of AB 51 makes clear that it would apply to those candidates as well as employees. Now, the text of AB 51 also makes clear that it does not invalidate arbitration agreements otherwise enforceable by the Federal Arbitration Act. And there seems to have been some confusion, at least what I've been hearing from some clients when AB 51 originally came out, and even after the recent Ninth Circuit decision, that some clients and some employers were of the belief that AB 51 somehow on its own could invalidate arbitration agreements. But that's not what AB 51 does. I know a couple of other of my colleagues, we went through the legislative history of AB 51 before this went into effect, just because we anticipated this would be such a significant issue. And just by way of some background, AB 51 was the second attempt by the California legislature to make mandatory arbitration agreements unlawful. The first attempt was actually vetoed by the governor on the grounds that it would likely be preempted by the Federal Arbitration Act. And so this time around, what the legislature decided to do was recognize that the Federal Arbitration Act wouldn't apply to AB 51 insofar as it would try to invalidate any arbitration agreement. And so the reason that distinction is important is it was a novel way that the legislature came up with to try to circumvent the FAA by saying, well, we're not trying to legislate anything that would say that, well, if you have an agreement governed by the FAA, our law is going to actually invalidate it. It is just simply going to impose a penalty if an employer tries to mandate arbitration agreements. And so that's the context of AB 51. And in terms of the potential consequences, it includes civil as well as criminal sanctions, and also the recovery of attorney's fees for any lawsuit that would be brought based on a violation of AB 51. Now, AB 51 was initially challenged by the Chamber of Commerce in the Eastern District of California. The Eastern District of California granted an injunction on the grounds that the Federal Arbitration Act likely would preempt AB 51. And that was subsequently appealed to the Ninth Circuit, and that's now that's the next slide we're going to discuss. So if we can move to the next slide. Now, the Ninth Circuit's decision in the Chamber of Commerce versus Bonta had a lot of nuances and a lot of legal gymnastics. But if I could summarize the outcome of the Bonta decision as concisely as possible, or at least as concisely as I'm able to do it, it comes down to this. If an employer chooses to have a mandatory arbitration agreement, and if the employee agrees to sign the mandatory arbitration agreement, then the Ninth Circuit held that the Federal Arbitration Act preempts AB 51 and there can be no penalties. And the reasoning for that is that the Ninth Circuit said state law cannot make unlawful what federal law deems to be lawful. So if we have the Federal Arbitration Act that says that arbitration agreements are lawful as well as enforceable, state law cannot try to circumvent that by saying, well, we're going to criminalize and we're going to sanction behavior that would be permissible under federal law. And so in this first situation, the Ninth Circuit was saying, well, once you actually have an arbitration agreement, because that is something lawful under federal law, state law can't touch it. And so to the extent there are any penalties, that those would be off the table. The Federal Arbitration Act would preempt. Now, the somewhat unexpected part of the Ninth Circuit decision involves the second part of this, where if an employer decides to have a mandatory arbitration agreement, but the employee refuses to sign the arbitration agreement, then the Ninth Circuit held AB 51 remains viable. There is no FAA preemption. And the reason for that is the Ninth Circuit found that the FAA only applies if there is an actual arbitration agreement. AB 51 targets pre-agreement behavior. And so if there is no agreement in the first place, then the FAA has no place in that analysis. And so if there is no arbitration agreement actually entered into, then the AB 51 penalties are on the table and those remain viable. Now, the status of this case is that there is a petition for an en banc review pending before the Ninth Circuit. In February, specifically on February 14th of this year, the Ninth Circuit decided to defer the decision on the en banc petition until the United States Supreme Court decides the Viking River Cruises case, which involves whether PAGA is subject to bilateral arbitration agreements under the FAA. So the status, the bottom line is currently the injunction by the Eastern District of California actually remains in place because the Ninth Circuit hasn't issued a mandate yet. Even though a portion of the Eastern District of California's decision was reversed, and that deals with the bottom half of this slide, since the mandate hasn't been issued and remains essentially stayed until the United States Supreme Court decides Viking River, which we expect to be by the end of June, the injunction remains in place. And the injunction, importantly, only enjoined the government and the government agencies from enforcing AB 51. And one question we often get is, well, what does that mean for private causes of action? And strictly speaking, the injunction doesn't enjoin private individuals from filing a lawsuit based on AB 51. However, neither I nor I don't believe any of my colleagues have seen any case brought based on AB 51. Usually this would probably be brought under PAGA, for instance, and the argument is that somebody is a representative of the state of California and the state of California is enjoined from enforcing this, so how can a PAGA representative bring a claim for a violation of AB 51? But the bottom line is the injunction essentially remains in place, and we still have yet to see how the Ninth Circuit will decide the petition for en banc review, and we could certainly expect a writ to the United States Supreme Court, regardless of what the Ninth Circuit decides in terms of the petition for en banc review. Next slide, please. And so now the question is, well, what do we do in the meantime? And that's something I know Andrew, Candace, and I, we've spent quite a bit of time counseling clients on. And so what we tried to do is just highlight a few of the possible strategies that various clients have either chosen to pursue or that have considered pursuing. So the first is, well, if you want to avoid AB 51 entirely, you can have voluntary agreements. Now, one thing that we certainly have discussed with clients is, well, even if you don't want to have voluntary agreements for all current employees, if you don't have an existing arbitration agreement in place, at least consider it perhaps for new employees and new hires, because somebody who is starting their employment, they're more likely than not to sign the documents presented to them during the onboarding process. And that has played out as true, at least anecdotally, that there doesn't seem to be as many challenges or objections to an arbitration agreement, even if, especially if one is voluntary agreement and if that is presented during the onboarding process. And one important caveat when we're on the topic of current employees versus new hires, if you do have an arbitration agreement already in place under the terms of AB 51, the law doesn't apply to any arbitration agreements that were entered into prior to January 1st, 2020. So if you have an agreement that's already in place prior to January 1st, 2020, then employers should be mindful of whether they want to incur any risk under AB 51 by trying to roll out a new arbitration agreement. The second possible strategy, which ties to what we were just talking about, is avoid providing the new arbitration agreements to employees who signed agreements prior to January 1st, 2020. And one thing, though, to keep in mind, and I think it's worth tracking, what the United States Supreme Court will decide in the Viking River Cruises case. I know this is outside the scope of what we're talking about here, but there might need to be some changes to arbitration agreements if the United States Supreme Court rules in favor of employers in that case. Third strategy is continued employment as assent. And this would be something to consider if an employer wants to have a mandatory arbitration agreement, but wants to minimize as much risk as possible under AB 51 by trying to have as much participation in the arbitration program as possible. California, as well as many other states, recognize that an arbitration agreement can be entered into not only by a signature, but also by having the agreement expressly state that by continuing their employment, the employee is assenting to the arbitration agreement. There are some conditions that are required for this to happen. Most importantly is that the agreement makes clear that the way that the employee is going to be assenting is by continuing their employment, and the employer also needs to establish that the employee in fact received the arbitration agreement that had that disclosure. The fourth strategy is having an agreement that is just silent and frankly ambiguous on whether it's mandatory or voluntary. And so you can imagine an agreement that says nowhere that it's a condition of employment, but at the same time doesn't say anywhere that it's voluntary, with the hope that with that ambiguity would weigh in favor of the employer, at least insofar as more employees would sign the arbitration agreement. Some clients have chosen to pursue this route and at least preserve the potential argument that an arbitration agreement, the arbitration agreement at issue was voluntary by just relying on the ambiguity. So that's one possible strategy as well. And then finally is to not have a freestanding agreement, which is something I personally recommend, but to instead have it part of an employee handbook or as a freestanding policy that isn't signed per se as a contract, but instead might be acknowledged, just like a new employee handbook might be. There are also some requirements when it comes to that and that approach, and courts are increasingly scrutinizing that approach as well, because they feel that courts are increasingly finding that there is a stronger element of procedural unconscionability when it comes to that. But these are just a couple of possible strategies when weighing the benefits and risks. Once given the uncertainty of AB 51, the benefits of trying to have as many employees as possible subject to an arbitration agreement, while at the same time trying to balance the potential risk that might come about if AB 51 is in fact not preempted by the FAA. I know that was a quick overview of BONTA and AB 51. And with that, I will hand it over to Candace.
Thanks, Daniel. So while we're on the topic of barriers to arbitration in California, we want to talk about two bills that passed in the last couple of years that have impacted how arbitration procedures are handled by arbitration providers. So let's turn to Senate Bills 707 and 762. The most draconian of these barriers, Senate Bill 707, became effective on January 1st. It's actually 2020, with the enactment of Code of Civil Procedure Section 1281.97 et sec, codified under the California Arbitration Act. And as the legislature indicated in enacting 1281.97, it was concerned that companies were strategically refusing to pay arbitration fees, thereby stalling and obstructing the arbitration and severely prejudicing claimants who were, quote, stymied from pursuing their legal rights and denied any semblance of justice. The legislature cited the defendant's conduct in a case called Sink versus Aiden Enterprises, a Ninth Circuit decision from 2003 as indicative of the type of conduct that the statute sought to address. In sync, mind you, an opinion that was issued 17 years prior to the enactment of SB 707, the plaintiff filed a lawsuit in May of 2000, and a motion to compel arbitration was granted in March of 2001. However, the employer did not pay arbitration fees by the August deadline, and although it received 2 letters reminding them to do so, one in June, 2 letters in June, and a letter from an opposing counsel indicating that default would be sought if the fees were not paid. Thus, the arbitrator canceled the arbitration hearing, which was set to start in August of that year, and entered default. The Ninth Circuit held that the right to arbitration had been waived by the defendant's refusal to pay the fees, and it explained that to hold otherwise would allow a party refusing to cooperate with arbitration to indefinitely postpone litigation, because the party owing the fees could just repeatedly not pay them. So with that background, let's look at Senate Bill 707. These statutes, sections 1281.97, 1281.98, and 1281.9, provide that if an employer fails to timely pay fees for the arbitration, the employee would be entitled to either withdraw the claim from the arbitration and proceed in court, or otherwise compel arbitration, whereby the employer would be required to pay the employee's reasonable attorney's fees and costs related to the arbitration process. And on top of challenging jurisdiction, the employee could also be awarded monetary sanctions, and the employer could be hit with even worse, an evidence sanction, terminating sanction, or even a judgment by default. SB 707 applies to fees due both at the inception of a case that are required for the case to move forward in arbitration, and fees that become due during the pendency of the arbitration, which are usually the arbitrator's fees. SB 707 required that fees be paid within 30 days after the due date, and that failure to do so would result in a material breach of the arbitration agreement and a waiver of the right to compel arbitration under the California Arbitration Act. Next slide. Next slide. You can also see that, sorry, go back one slide. You can also see that Senate Bill 707 extended to section 1281.97 to fees and costs required to continue the arbitration proceeding. It tolls the statute of limitations with regards to all claims that are brought or that relate back to any claim brought in arbitration as of the date of the first filing. So in that circumstance, if an employer is found to be in breach of the arbitration agreement for failure to timely pay fees, the employee can seek relief in court to enforce the arbitration agreement, or can pursue the claims in court or another forum, and the statute of limitations is told on their claims is told from the date that they first filed the action. SB 707 also permits the arbitrator or arbitration provider to institute a collection action at the conclusion of the arbitration for payment of all fees associated with the employment or consumer arbitration proceeding, including the cost of administering any proceedings after the default. Next slide. One potential upside to SB 707, at least prior to this year, was that employers could take a measure of solace in the fact that only the arbitration initiation fees would be due at the inception of the arbitration, with the arbitration hearing fees or the arbitrator deposits becoming due at a later time, usually much closer to the actual hearing. And now that has to change as a result of Senate Bill 762. Senate Bill 762 took effect this year in January. It added section 1657.1 to the Code of Civil Procedure and amended sections 1281.97 and 1281.98 of the Code of Civil Procedure that we just looked at on the last two slides. SB 762 added a requirement to the law that arbitration providers in consumer or employee arbitrations, such as AAA or JAMS, must immediately provide an invoice to all parties to the arbitration for any fees and costs required before the arbitration can proceed. The invoice must state the full amount owed and the date that the payment is due. And to avoid delay, absent an express provision in the arbitration agreement stating the number of days in which the parties to the arbitration must pay any required fees or costs, the arbitration provider shall issue all invoices to the party as due upon receipt. So what this means, the practical effect of this is that you'll see in arbitrations moving forward that the arbitration provider will send the initial case management fees very soon after the case is filed and the procedural requirements are met by the claimant. Those fees are now due upon receipt unless otherwise specified in the arbitration agreement. And if you fail to pay those fees, if an employer fails to pay those fees within 30 days, they're in material breach of the arbitration agreement. In addition to the initial case fees, what we're now seeing is that arbitration providers are sending invoices for the amount of anticipated fees or a substantial portion of the amount of anticipated fees by the arbitrator. So if, for example, you have a 3-day arbitration, the arbitrator might estimate that their fees for that case, including the hearing, will be $30,000, and employers will receive an invoice for somewhere between, let's say $10,000 and $30,000 that are due, and that payment is due again upon receipt. Prior to SB 762, again, those types of invoices were usually sent toward closer to a hearing date. The purpose of SB 762 is to close the gap with respect to the payment of fees and costs for arbitration. The prior law stated that if the drafter of the arbitration agreement did not pay all fees and costs before the arbitration could proceed within 30 days of the due date for paying those fees and costs, they were in material breach. But SB 707 did not impose any requirements on when an arbitrator must send the invoices or whether and how the payment's due date must be disclosed. So that has been modified by SB 762. The bill further provides that where an arbitration agreement does not establish a time frame for paying an arbitration invoice, it's due upon receipt, as I just mentioned. Additionally, the bill requires all parties to an arbitration to agree to a payment extension before the arbitration provider will allow a payment extension. So absent an agreement from the employee or the employee's attorney, the arbitration provider will not extend the deadline to pay the fees, and they will not extend the 30-day deadline to pay the fees under SB 707 to avoid default as well. Finally, SB 762 adds a code section addressing the time to perform under contracts of adhesion, which include arbitration agreements, stating that any time for performance of an act set forth in a contract of adhesion must be reasonable. So what this means is that to the extent that you include a provision in your arbitration agreement that modifies the deadline or the due date for any fees due prior to the initiation or during the pendency of an arbitration, that the deadline must be quote unquote reasonable. The ramifications of these two laws are pretty obvious, but most businesses, most employers do not want to pay the cost of an entire employment arbitration at the outset of the case. And this is because, unlike arbitrations between businesses in which each party may contribute to the payment of fees and costs equally, an employer is usually obligated to pay for the employee's portion of the arbitration fees. And so the amount that might be due at the outset of the case can be significant, and it's shouldered almost always entirely by the employer. Before the law was passed, employers could budget for the anticipated costs of a hearing, and that could take place months later, and might often try to strategically engage in settlement discussions prior to the payment of those large arbitrator deposits and invoices. But Senate Bill 762 all but removed that option. So what to do now in response to Senate Bills 707 and 762 in order to avoid, one, a waiver or default under these new laws, and two, to respond to a circumstance where you might find that fees were not timely paid. The first strategy that we've talked with our clients about is amending the arbitration agreement to provide provide a reasonable time for payment in the express provision of the arbitration agreement, stating the number of days in which the parties to the arbitration must pay any required fees or costs. And you can structure that in a way where you set a deadline for payment of fees, both required at the initiation, required to initiate and proceed to arbitration, and also a deadline to pay required fees and costs to continue the arbitration proceeding to hearing. For employers and businesses, best practice is to establish clear payment timeframes in your arbitration agreement. But obviously, we want employers to also be mindful of what Daniel just spoke about in terms of AB 51. And so you'll have to weigh the risks and benefits of modifying arbitration agreements that have already been signed by employees prior to January 1st, 2020. But by taking the affirmative step of specifying a time period, you may be able to avoid some crippling upfront payments that would otherwise put employers in a tough spot. The second strategy is to set up robust protocols for receiving and paying invoices. You could do this as either part of your arbitration agreement, where it's specified in the actual agreement that all invoices be provided to a particular person or email distribution list in order to be effective notice. Or you can communicate with the arbitration provider by email or otherwise in writing, designating a person or persons or email to receive all invoices. This will help ensure that invoices are delivered to the appropriate persons and timely received and paid. You could also set up a payment management system, again, along the lines of designated person or a process whereby all fees are handled in a particular way. That might look like fees being paid by your outside counsel firms or by your finance department within so many days of receipt. But setting up a procedure and process for handling arbitration fees is one way to avoid one of these fees sort of slipping through the cracks and being missed. And then also communicating with the arbitration provider about when fees are due and refund procedures if there's some concern that that fees are being paid for upfront for cases that are likely to settle or be dismissed early on. Usually arbitration providers are willing to discuss refunds, particularly of arbitrator fees, because those fees are not, oftentimes those fees are paid and the amounts due exceed the amount that the arbitrator actually might incur by the time that the case is resolved. It's a good idea to provide a copy of your arbitration agreement to the arbitration provider if you include these new terms, to make sure that they are, one, aware of them and that they will comply with the requirements and don't have any issues complying with those requirements before they are rolled out to employees. And now, if you find yourself in the unfortunate situation where fees have not been timely paid, and the claimant or claimant's counsel is unwilling to stipulate to continue arbitration, depending on the circumstances that led up to the untimely payment of fees, you may consider these several options. First, you can file a motion to compel the case back to arbitration. Now, if that motion to compel is unsuccessful, SB 707 and 762 do provide a relief to a claimant in the form of reimbursement of attorney's fees and cost to oppose the motion. But in bringing the motion, you can might rely on the legislative history of Section 1281.97 under SB 707, which acknowledged that the statute was intended to build on existing body of case law. And that existing body of case law, in terms of waivers of arbitration agreements, does not support a finding of material breach and waiver where, for example, fees were not paid due to attorney mistake, or where an employer was unaware of the fees due or the deadline. You might also, again, bring as part of your motion to compel arbitration a claim back to arbitration, and an argument where you seek relief under Code of Civil Procedure Section 473B. That's the attorney mistake provision that provides that a court may, upon any terms as maybe just, relieve a party of his or her attorney's mistake, and that an administrative error of the type where invoice was not received is the type of mistake, inadvertent, surprise, or excusable neglect, under which California Civil Procedure 473B provides relief. And finally, if you find yourself in a situation where you're having to compel claims back to arbitration after they've been after the matter has been closed for non-payment of fees, you might consider an argument that the fees that SB 707 and SB 762 are preempted by the Federal Arbitration Act. Similar to AB 51, the legislature attempts to circumvent a challenge under the FAA by opining that Section 1281.997 with a narrowly tailored response to address what they thought were strategic refusals to pay fees, and the statute itself should not frustrate the purpose of the FAA. But where you have a situation where fees were not paid simply due to inadvertence, or the payment of the fees were only slightly late, you might have a valid argument that material breach and waiver would frustrate the purpose of the FAA and therefore preempt Section 1281.97. All right, with that, we'll hand it over to Andrew.
Thanks, Candace. Turning to our third topic today, one of the plaintiffs' bar increasingly favorite tactics in opposing petitions to compel arbitration is to challenge the validity of an electronic signature. And unfortunately, there have been a number of recent decisions, both at the trial level and at the appellate level, that have upheld challenges to electronic signatures on arbitration agreements. And so we will go through and talk about the best strategies to avoid those pitfalls. First, let me give you a quick example of one of the cases that has come down recently. I'll just give you a quick summary of some of the facts there. So the employer in that case submitted a declaration from one of its HR managers describing the electronic signature process that the company used. The employees were assigned a temporary passcode. The employees were then required to log in, change that password to a confidential one before they could sign any of the documents in the system. The manager also testified that no other person at the company had the ability to access that password, and presented evidence that at the same time the employee signed, electronically signed the arbitration agreement, she also signed a number of other documents that she was not contesting. In response, the plaintiff testified expressly that she knows she did not sign the arbitration agreement because her husband is an employment lawyer, and that she would never sign such a thing without talking to him, and he would never have counseled her to sign such an agreement. She also submitted a declaration from a information securities expert who opined that the company's system was not sufficiently secure to authenticate an electronic signature because the network connection that was used was unencrypted, and that individuals in the company's IT department had access to a utility that would allow them to change a password. Therefore, the plaintiff's expert opined that it was impossible to dismiss the possibility that somebody went in and electronically signed the agreement other than the plaintiff. Note, the expert didn't say that she knew that that is what occurred. She simply said that it was impossible to rule out that possibility. Based on that testimony, the trial court found that it was at least possible somebody could have stolen the password, or somebody could have reset the password. And despite the fact that the evidence submitted by the company actually matched evidence in other appellate cases that was upheld as being sufficient, the trial court said that there was a dispute as to the evidence, and the court was going to credit the plaintiff based upon her credibility, and find that the employer had not met its burden of showing that the electronic signature was authentic. And on appeal, the Court of Appeal upheld that determination, basically finding that it was a factual finding of the trial court, and that the Court of Appeal was not in a position to disturb that. So it's a pretty shocking decision to those of us that were following it. And so the question arises, So how do you avoid finding yourself in a similar situation? First, quick little basics on the law. California has adopted the Uniform Electronic Transaction Act, which recognizes the validity of electronic signatures. And in California, there's a three-step process to authenticate an electronic signature. Initially, the petitioner here, the company, is not actually required to authenticate the signature unless it's challenged. It is simply sufficient to either attach a copy of the agreement to your petition or to quote verbatim the language. The burden then shifts over to the other party, and if they challenge it, then there's a third prong. Often what a plaintiff will say is either they don't recall signing the agreement, but as, for example, in the case that I just mentioned, they might make an affirmative statement that they know they didn't sign the agreement. In that situation, then the burden now shifts to the employer to actually prove, based upon a preponderance of evidence, that the electronic signature is in fact authentic. Next slide, please. It's really important that in meeting that third prong, the employer presents the strongest evidence possible. And the reason for that, as I mentioned, is that on appeal, it's extremely hard to overturn a trial court's factual determination, because a trial court's ruling in this matter is reviewed under the abuse of discretion standard. And the question on appeal is whether the evidence was uncontradicted and unimpeached, and of such a character and weight as to leave no room for judicial determination that it was insufficient to support the finding. Important to note, the Court of Appeal is not going to disturb a trial court's finding weighing conflicting evidence or the credibility of witnesses. And as one appellate decision noted, it's almost impossible on appeal to prevail by simply arguing that disputed evidence below compels a ruling in the appellant's favor. Next slide. So let's take a look at some of the situations in which a court has found that the employer has met its burden and what it is that the employer submitted in terms of evidence below. One way of doing it, and I should note that there is no one method. The key is demonstrating that the efficacy of the security procedures, and one way of doing it is to submit a declaration from somebody saying, I actually watched the person go through the e-signature process. Of course, that's often not feasible, especially in a remote environment. Other pieces of evidence that the court has found persuasive. The employee was required to log in using a unique username and password chosen by the employee. The employer was able to submit an audit report that identifies when the signature was applied to the document and showing the actual username, ID, and the IP address associated with the computer for the e-signature, and in fact, that same IP address appears on multiple documents that were signed within close temporal proximity to the arbitration agreement. Critically, you'll want to make sure that there's evidence to show that no other person had access to the username or password. Another way of dealing with this is the actual use of a system that complies with the e-sign statute, such as DocuSign or Adobe, which have strong validation and security protocols built into them. Another key issue in the decisions is the difference between where an employee says that she doesn't recall signing versus a situation where the employee says, I know I didn't sign. In the former, it's much easier to prevail than in the latter. Next slide, please. So now let's flip the coin and take a look at the types of factors that the court looks at when it denies the employer's petition to compel. As mentioned, one of the key factors in those cases is where you have an employee who is affirmatively stating that she knows she didn't sign the agreement, and coupled with a declaration from the employer that simply summarily asserts that the company knows that the agreement was electronically signed, but doesn't actually explain on what basis the company is inferring that the electronic signature is in fact an act of the plaintiff. And critical in those cases is the employer often does not specifically state that the user ID and the password or PIN code is specific to the employee, or that an HR manager or somebody in IT or somebody else had access through the onboarding portal to access information in the employee records that would be used to change a password. Another point that's important to note is that even where a company uses DocuSign, it's critical that you actually present evidence as to how DocuSign works and the security protocols. There have been cases in which the employer has sought to take judicial notice of DocuSign's protocols simply by asking the court to take judicial notice of DocuSign's statements on their website, and the court has declined to do that, noting that those are not matters that are proper for judicial notice, and therefore saying that while the company used DocuSign, there's no evidence in the record as to how DocuSign actually works. Next slide. So that brings us to some key takeaways for employers in terms of what you want to make sure that you do to increase the probability that your petition to compel arbitration will be granted. First, and critically, any evidence that you submit in terms of a declaration needs to be admissible evidence. Often, declarations will simply say something like the individual has, could or would have testified competently if called. Well, that naked statement is not sufficient. You need to actually lay out facts that establish the personal knowledge of the declarant and the foundation that the person has for making these statements. Again, if it's possible, it's great to actually have somebody say that they saw the employee actually go through the e-signature process. Often that's not going to be possible. If you're relying on records, make sure that the declarant establishes that they are in fact the custodian of records. You may also want to submit a declaration from an IT systems consultant or potentially an outside expert detailing the security protocols that are used. Make sure you establish that the applicant's, the employee's username and password are unique to them, next slide, and that no other person has access to those IDs or passwords. It's also great if you have the ability to do so. Provide an audit report showing the date and time of the signature, the IP address of the computer used, and that other documents were electronically signed from that IP address at the same time as the arbitration agreement. Be careful that you don't just put in a generic description of how your process generally works. You need to make sure that you state that not only is this your general process, but specifically with regard to the plaintiff situation, it worked this way. There are cases in which the court has said, fine, the employer has described their process generically, and that process is probably fine, but that the employer did not go the next step and actually say that they know that that's how it worked with regard to the plaintiff, and that left the door open when the plaintiff said, yes, maybe that's how it works generally, but that's not how it worked for me. Again, if you use DocuSign or Adobe as your system, that's great, but you still need to make sure that you have somebody explain the architecture or the data flow behind DocuSign or Adobe, at least with regard to the security protocols and the validation processes, to ensure that the court actually accepts that. But to end on a good note, what we see most often is employees simply saying that they don't recall signing it, and that should not be sufficient if you are following the takeaways that we've laid out here, and the employee simply says, yeah, but I don't remember signing this. The company in that situation should manage to prevail and hopefully have its arbitration agreement enforced. And I'm going to stop there, and I realize we are a couple of minutes over, which means we're probably not going to be able to get to the questions today in the interest of time. However, what we will try to do is reach out to the individuals who submitted questions and see if we can answer those directly through email or otherwise. And certainly if you have any other questions that you haven't submitted, please feel free to reach out to any of the panelists. We're happy to chat with you either by phone, by email, otherwise, or any of the other lawyers that you work with here at Seyfarth. And at this point, Catherine, do you have the CLE code for people?
Yes, thank you for attending. This concludes today's webinar. The CLE for this webinar is SS, as in Seyfarth Shaw, SS 2631. Again, that is SS 2631. Thank you all for attending.